Well, hello everyone, and welcome to today's webinar entitled "The Legal Discussion of the FIFRA ESA Consultation Process Over Time." I'm Chris Boomsma, CEO here at the Council for Agricultural Science and Technology, also known as CAST, and I'm happy to kick off this event and then hand it over to our moderator and presenters. So with that, let's get started on this presentation. First of all, you might have seen in the first slide that this is webinar number 2 in the series, and more about the upcoming titles here at the end of the presentation. But do note that this is number 2. We had number 1 already, obviously, then, and you're welcome to go back and consult those materials. We do post all of them, the recording, the slides. Those are made available to you through the CAST website. So think about that and do sign up for the rest of the events. A few quick facts about CAST. First of all, we're a 501c3 membership-supported nonprofit organization formed in 1972 as a result of a 1970 National Academy of Science report. We are nonpartisan, apolitical, pride ourselves on being science-based and unbiased. And you can see we have a membership made up of many different organizations and organization types. In 2022, we were happy to celebrate our 50th anniversary. On this slide, you can see both our mission and vision. We try to coordinate and convene networks of experts to assemble, interpret, and communicate credible, unbiased, science-based information to policymakers, the media, the private sector, and the public. Our vision, a world where decision-making related to ag, food, and natural resources is based on credible information developed through reason, science, and consensus building. You can see how we go about our mission, and a big piece of that is through the help of many volunteer contributors. We have a variety of boards, a lot of task force participants, and a lot of scientific experts that contribute to the publications we put out, the webinars we put out, and certainly an example of that is what you see today with this publication. We are very, very grateful for our contributors, all of our volunteers. Without them, this organization would not be able to survive and thrive as it does today. So thank you to each one of you who do volunteer. At this time, I'm going to hand the webinar over to today's moderator, Bernalyn McGahey of Compliance Services International. Bernalyn is going to take it over, introduce the rest of the folks who are going to participate in today's event, and we'll kick it off from there. So Bernalyn, thank you for coming. Thank you for coming back. You were on the first webinar. We're happy to have you here today as the moderator. Just take it away when you're ready.
All right. Thank you very much, Chris. And good to be here again and continue with this series. Our first paper was excellent. We got excellent questions, which I'm sure those of you listening in will do the same today. Today, we will hear a presentation from Bridget Rollins from University of Arkansas's National Agricultural Law Center. And she will be presenting the sort of the legal side of the history that we went over last time and what the law says, or the 2 laws actually that we're working under. And her efforts have been put together with Harrison Pittman, as well as oversight by the coordinators of this series, which is myself, Stanley Culpepper, with University of Georgia, and with Tony Bird Syngenta, who is joining us today, but he's driving, so he probably won't be visible. We're here to support the speaker and moderate the session. And if she has any questions for us that she wants to pass along, we'll stand by and see what we can do to help. Again, very, very happy to be here, and thank you for the efforts at CAST to coordinate this session and put it together and make it happen. With that, Bridget, I'll turn it over to you.
Thank you, Bernalyn, and thank you to the entire CAST team. I'm really thrilled to be with you all here today. As Bernalyn said, we are going to be going over today sort of the legal aspects that are at play with this sort of FIFRA ESA consultation process. We're going to walk through the 2 different laws that come into play here, talk about EPA's, some of their historical attempts to sort of bridge this gap, and then take a quick look at what EPA has proposed, how that sort of fits into both of these statutes, and maybe hopefully have some discussion about some outstanding questions. Do my best to answer some of your questions there and take a look at what's kind of coming down the road. So with that in mind, I'd like to go ahead and get started, and I think we're going to move on to our first slide. So just very briefly, as Bernalyn mentioned, I'm with the National Agricultural Law Center. We are a group that we're essentially the nation's primary resource for agricultural and food law research and information. We're objective, we're nonpartisan, and we're really just here to help folks like you understand what the law is and how it impacts agriculture. Next slide, please. All right, so again, just very briefly, I'm sure most of you are already familiar with why we're here today, but for those of you who are maybe just new to this information, in early 2022, EPA announced that it was going to be taking steps to develop a new policy for how it would better increase its Endangered Species Act compliance when taking actions under FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act. What we know about this plan so far through work plans that EPA has released, as well as other documents that it's released earlier this year, this plan is going to focus on EPA is going to be developing a series of what they're calling early mitigations that are intended to reduce pesticide impacts to species that are listed as either threatened or endangered under the ESA. And as most of you can probably deduce from that, if this plan is implemented as it's proposed, it's going to impact essentially all pesticide users. It's a very broad plan. And to really kind of understand where EPA is coming from with this new policy proposal and to get a sense of how well it's going to function, we do need to take a look at those two laws underlying this plan. So if we could move to the next slide. Fantastic. So the first law that's going to come into play here is the Endangered Species Act. This act was passed in 1973. We're actually right at the 50th anniversary of the ESA. President Nixon signed it into law in December of 1973. And the purpose of this law is to conserve threatened and endangered species and the ecosystems that those species depend on. This law is administered by both Fish and Wildlife Service and the National Marine Fisheries Service. These two agencies are responsible for identifying and listing threatened and endangered species and designating critical habitat for those species. Once a species becomes listed under the Endangered Species Act, it receives the full protection of the Act. That includes prohibitions on what's referred to as take, which is a very broad term. It includes everything from sort of general harm to a species to actually killing a listed species. And one of the other primary protections that a species that's listed under the Endangered Species Act receives is sort of this consultation protection. So while Fish and Wildlife Service and National Marine Fisheries Service are responsible for administering the Endangered Species Act, all federal agencies have responsibilities under this act. And this comes into play in sort of this duty to consult. So whenever a federal agency carries out an agency action, they have a duty under Section 7 of the ESA to consult with either Fish and Wildlife Service or National Marine Fisheries Service to ensure that that action that the agency is carrying out will not jeopardize any listed species or destroy or somehow adversely modify critical habitat. Next slide, please. So Section 7 consultation, again, this is something that applies to all federal agencies. It comes into play whenever an agency is proposing to carry out an agency action. And for this purpose, action is defined very broadly as anything an agency authorizes, funds, or carries out. It's pretty broad. And then the purpose of Section 7 consultation is to ensure that no agency's action is going to jeopardize a listed species. And again, jeopardy here is defined as an action that is reasonably expected to reduce appreciably the likelihood of both the survival and recovery of a listed species. So when we're talking about jeopardy, we are talking about an action that could either result in a species going extinct or interfere with the recovery of that species. That's important to keep in mind. Section 7 consultation is a fairly straightforward process. It sort of starts with what's referred to as informal consultation. This is sort of when the ball is sort of in the action agency or the agency that's sort of taking the proposed action, sort of in their court. So during informal consultation, this first step of the Section 7 consultation process, the action agency is going to make a determination as to whether or not its proposed action may affect any listed species or critical habitat. And this is a really low threshold to clear. It includes any possible effect to a species at all. So if the action agency determines that its proposed action may affect any listed species, it's going to then go ahead and make a secondary finding, and it's going to determine whether or not those impacts are not likely to adversely affect any listed species, or whether those proposed impacts are likely to adversely affect a listed species. If the agency finds that it's not likely to adversely affect a listed species, it's going to reach out to either Fish and Wildlife Service or National Marine Fisheries Service to get sort of the services basically to kind of get their thumbs up to say, okay, the services agree, we're not going to adversely impact any species with this action, so now we can move forward. However, if the action agency finds that its proposed action is likely to adversely affect a listed species, or would is likely to adversely affect critical habitat, then it needs to proceed to formal consultation. Next slide, please. So formal consultation, this is sort of when the process kind of gets passed more over to the services. Essentially, formal consultation revolves around the development of a document called a biological opinion, or a BIOP. So this is a very detailed document that, again, this is the services produce this document, and it includes a variety of information, usually a lot of detailed information about the proposed actions, expected impacts to listed species or critical habitat. There's usually going to be an environmental baseline included in the BIOP. This is sort of, what the general baseline is prior to the agency action coming into play. The BIOP will also, and this is very important, contain the service's determination of whether or not the proposed action is going to cause jeopardy to a listed species or result in the destruction or adverse modification of critical habitat. If the service makes a jeopardy finding, then the BIOP is going to include what are called reasonable and prudent alternatives, which are essentially, as well as reasonable and prudent measures. So these are essentially ways that the agency can either minimize or mitigate the impacts of the proposed action to avoid jeopardy, or even different actions or activities that the agency could take to modify or change its action that will still result in the same outcome, but essentially, eliminate or at least drastically reduce the likelihood of jeopardy. Once the biological opinion is issued, consultation is at its end. The consultation process is satisfied. And then the agency can decide to either adopt the BIOP's recommendations, carry out the agency action without them, and just sort of kind of knowing that they will be violating the ESA there, if they result in take or jeopardy of a species. Or they can choose to reinitiate consultation if they've altered the action that they're going to carry out, or take other steps that they believe will reduce harm to species. So that is the ESA's formal consultation process. And again, this is a requirement for any agency taking out any agency action. Next slide, please. So that's the background on the ESA. And we really could spend a lot of time on just the Endangered Species Act itself, but for the purposes of what we're talking about today, that really is the crucial thing to understand, is that consultation requirement. The other statute that we need to take a look at is FIFRA. So most of you, I would imagine, are somewhat familiar with FIFRA. This is the primary federal statute regulating pesticide use in the United States. Before a pesticide can be sold or used in the US, EPA needs to register that pesticide under FIFRA. The registration process is, fairly long, fairly comprehensive, and it essentially requires EPA to make a determination that the pesticide product will not have unreasonable adverse effects on the environment when used as intended. So sort of when used according to the label that would be attached to it. FIFRA defines unreasonable adverse effects on the environment as any unreasonable risk to man or the environment, taking into account the economic, social, and environmental costs and benefits of the use of any pesticide. So this is a pretty straightforward balancing test. This unreasonable adverse effects on the environment really asks EPA to go in and take a look at all the potential costs and all the potential benefits associated with using a pesticide, and weigh them against each other to make this determination. This is very different from the ESA's may affect standard, which is a much more straightforward yes, no standard. So keeping that all in mind, right? We know that registering a pesticide under FIFRA is an agency action. And I'm going to have us go to the next slide, please. Fantastic, thank you. But again, registering a pesticide under FIFRA is not the only agency action that EPA takes under this law. Other FIFRA agency actions include modifying a pesticide label, perhaps by adding a new use or by adding maybe new use restrictions. Another agency action under FIFRA would include registering a new pesticide active ingredient, re-registering a pesticide, carrying out registration review, and even in that registration review, there's multiple other agency actions that can come out from under that. If the agency releases an interim decision, or does something to adopt some new uses to the label of whatever pesticide it's reviewing, that could also be considered an agency action. And each of these actions, for the purposes of the Endangered Species Act, would be considered separate actions that require ESA consultation. And EPA carries out, numerous dozens, tens, hundreds of FIFRA actions every year. We can see how that might build up a pretty substantial workload just on that ESA consultation alone. Next slide, please. Thank you. And that's kind of how we got to the situation that we're in today. So for decades now, EPA has failed to fully consult over all of its FIFRA actions. And that's not me saying that, that's not an environmental group saying that, that is EPA has come out and very clearly stated that the agency has failed to fully comply with all of its ESA Section 7 consultation requirements when carrying out its FIFRA actions. And this has resulted in a series of lawsuits, usually filed against the agency, challenging a pesticide label for failure to comply with the ESA. These lawsuits are usually filed by environmental groups, sometimes farm worker or other citizen groups, and they're usually looking to vacate the pesticide label. And oftentimes they are successful in these lawsuits, either getting a successful court decision or a successful settlement. And this is primarily because of how the Endangered Species Act is written. There's not a lot of wiggle room. An agency is required to consult, and if it does not, then it has violated the ESA, and usually a court is going to rule in that direction, especially if the agency admits that it did not consult. And this has really resulted in a large amount of large workload for EPA. They have said that currently, with all of their court-ordered consultations, that schedule alone will take the agency expects will take it to 2030, perhaps beyond, to complete. And it's really in an effort to sort of reduce these lawsuits, create stronger pesticide labels, and come into full ESA compliance, that EPA has decided to launch this new ESA FIFRA policy. Next slide, please. And before we switch to taking a look at what EPA has proposed and sort of how it fits in with the two statutes that we've taken a look at, I do want to briefly mention that this is not the first time that EPA has attempted to sort of come into full ESA compliance for its FIFRA actions. And that's usually been because of that cycle that we just saw on that last slide, where EPA, has a period of time where it's not really fully complying. It is subject to a series of lawsuits, which then sort of prompt the agency to kind of revisit its approach. So in 1982, EPA developed what it called the cluster approach, where it would group together pesticides that had similar uses, and then conduct a Section 7 consultation for that entire group. During the 1980s, that's also when we saw EPA introduce what it calls Endangered Species Act bulletins. These are usually very geographically specific. They include language sort of directing whoever is in that geographic area to sort of adopt additional restrictions to applying a particular pesticide, usually to reduce impacts to listed species. And these get incorporated into a pesticide label with language sort of directing pesticide users to go check to see if there are any active bulletins in their area. So EPA first started using those in the 80s, and keep those in mind because we will be talking about those later. Then in 1989, EPA launched what's called the Endangered Species Protection Program. And this, again, was an attempt to help the agency fully come into ESA compliance by identifying species that the agency considered most vulnerable to pesticide impacts, and then working with Fish and Wildlife Service to identify counties where those species are located and develop, again, those geographically specific restrictions. And once again, we saw EPA there really rely on those ESA bulletins to kind of carry that out. And then in 2005, EPA switched to doing Section 7 consultation on an action by action approach. So as it, as it reviews a pesticide label or registers a new product, it would carry out Section 7 consultation that way. But really, none of these approaches seem to ever fully get off the ground. For one reason or another, nothing really seems to have stuck. So that's sort of how we got to the situation that we're in today. Next slide, please. So the new policy that EPA is proposing really does focus on these early mitigations. So these are new restrictions that are going to be added to pesticide labels to reduce the harm or really reduce exposure and impacts to listed species and critical habitat. And the goal of these early mitigations is to reduce the number of future consultations that result in those findings of jeopardy or adverse modification to critical habitat. So by introducing these mitigations here on this front end, the idea is that when EPA gets around to engaging in consultation over a particular pesticide, it will hopefully reduce jeopardy findings and therefore reduce the amount of mitigations that have to be introduced later on. Once again, EPA is developing these mitigations in two general ways. The first way that EPA is looking at is to kind of broadly divide out all registered pesticides into three general groups: herbicides, insecticides, and rodenticides, and then adopt mitigations specifically for those that would apply across those groups. And the other method that EPA is using is kind of identifying species that the agency concludes are particularly vulnerable to impacts from pesticides, and then kind of drafting individualized mitigation measures that are particularly tailored to those species. So we sort of see here kind of EPA taking both that cluster approach from 1982 and then that sort of species by species approach from, I think it was 1989, and kind of mixing them together. That's kind of interesting. The agency seems to have sort of gone back to the drawing board and also rated sort of its the back of the closet at the same time. Next slide, please. So I want to kind of take a look really quickly. Some of you might already be familiar with this. Maybe you've read it. What we know so far about this sort of group by group approach. Earlier this year, EPA released what it's calling its draft herbicide strategy. So this is sort of mitigation measures that EPA is developing to sort of reduce pesticide impacts across all herbicide labels. From what we can tell, EPA expects to include the early mitigations it's identified in this strategy on all herbicide labels. These mitigations fall into two primary categories: mitigation measures that are aimed at reducing pesticide spray drift, and then mitigation measures that are aimed at reducing pesticide runoff and erosion. Again, mitigation measures that EPA finds are going to be necessary across an entire pesticide use area are going to be included on the product's general label. So if EPA thinks that these mitigation measures are going to be required for wherever a pesticide is used, then it's going to include those directly on the label that is attached to every pesticide bottle. However, EPA has indicated that there will be some mitigation measures that are only required in specific geographic areas. And that for those, EPA is going to be relying on those Endangered Species Act bulletins. Now, thankfully, it's no longer the 1980s. Back in the day, to get those bulletins, you had to go to whoever your local authority was in your county to see if there were any bulletins necessary to you. Now, at the very least, we have the internet, so EPA will be posting all of these bulletins on its website, Bulletins Live 2. I do wish that website had a better name, but I did not name it. Next slide, please. So just very briefly, The spray drift mitigation is probably about what you would expect. Additional buffer requirements. Uh, EPA seems to be kind of recommending a broad approach: windbreaks, hedgerows, and hooded sprayers. And then for the runoff and mitigation, the runoff and erosion mitigations, EPA, this is sort of where, if you've heard anything about a mitigation menu or a point system, that's where this is coming from. EPA seems to be saying that for sort of each of these pesticides, if they've identified that a particular pesticide needs to have mitigations to reduce the amount of runoff or erosion from application, that it might assign, say, a point system. Maybe it says for this pesticide, it's 5 points. You need to reach 5 points. And then the applicator can go through the mitigation menu of mitigation activities and sort of select based on the amount of points they need and what mitigation measures they think will work for their best for their area, and sort of kind of mix around to meet those points. So that's what's getting proposed in the draft herbicide strategy. And if we could move to the next slide, please. And apologies if anyone can hear what sounds like a siren on my end. I'm in my office and they're doing their sort of weekly testing of the tornado sirens. Hopefully they will be done soon. So the other approach that EPA is taking, again, is sort of this tailored to specific species approach. This is going to be, again, introducing those early mitigation measures. These are targeted at specific species. So instead of applying across a broad category of pesticides, they're going to be tailored to address impacts to particular species. We're seeing, once again, that these mitigations are falling into two general categories, either avoidance or minimization. Avoidance mitigation measures, kind of like the name sounds, this is referring to areas where EPA is saying, you know what, we're just not going to allow pesticide applications anywhere in this area because this species is present, and the impacts are too, the agency is like, we think these impacts are just too much for the species, so we're not allowing spraying or application at all. And then mitigation measures, the minimization mitigations, apologies, there's a lot of M words here. The minimization mitigations identified in this particular approach, this vulnerable species pilot program. These are going to be similar to what we saw in the draft herbicide strategies. These are going to be mitigation measures focused on reducing spray drift, runoff, and erosion. And then once again, we are seeing heavy reliance from EPA on Bulletin's Life 2. All of these mitigations identified under this vulnerable species pilot program are all going to be geographically specific because they're all dependent on where a species is located. So these will be all identified under these bulletins and incorporated into the label with language sort of directing applicators to go check Bulletin's Live 2. Next slide, please. Right, yeah, and again, just kind of echoing what we saw in the mitigation measures proposed in the draft herbicide strategy. The spray drift mitigations, we're looking at spray drift buffers, some prohibitions on application method or droplet sizes. And then for the runoff and erosion mitigations, we are thankfully not seeing the pick list again over here, but we are seeing, you know, no applications when soil is saturated, when rain is in the forecast, and then the requirement of certain land use practices. Next slide, please. Very briefly, there have been some updates to the VSPP since the draft of it was first released. So in November 2023, so November of this year, EPA released a brief update to this, primarily addressing the categories of comments that it received and then outlining just a few of its next steps. So our primary takeaways from that is that EPA is planning to improve the species maps that it's using for the VSPP. This should be very, hopefully helpful to better tailor where these mitigation measures are going to be required, particularly those avoidance mitigation measures. And then the other primary takeaway from that update is that EPA is going to be working to clarify some possible exemptions to the VSPP. Right now, we don't really know what those exemptions will look like. But they are going to be working to clarify those, and they will be revisiting how the vulnerable species for this program are identified and selected. And they've said that they will provide further updates by fall of next year. So we'll see. Next slide, please. Just very quickly, because I know we're kind of running up on time for discussion, and I want to make sure we leave plenty of time for that. But Just looking ahead, our next steps, sort of what we're expecting to see next year as EPA continues to kind of roll out this policy. A final version of the draft herbicide strategy is expected sometime next year. I've heard early next year, but we'll kind of see what happens there. The agency is also planning to issue a draft insecticide strategy sometime next year. I've heard May. Again, we'll see what happens, but that is coming. So similar to the draft herbicide strategy, we will see a draft insecticide strategy. Again, EPA is going to keep refining and developing the vulnerable species pilot program. It's also said it's going to identify additional species. So it identified 27 initial species for this program. The agency has said it's going to work on identifying other species. We still don't know really how many it intends to include, if it's set a cap, what that's going to look like. And right now it's still kind of unclear when those mitigation measures will begin appearing on pesticide labels. At this point, we just don't know. Next slide, please. All right, so these are just sort of my final thoughts, and I hope will possibly help to kick off some of the discussion as well. So these are just some general legal and practical questions that I have heard from others that we don't really have great answers to right now, but I think are very prescient, especially as this policy continues to be developed and starts to get rolled out. I think the first question is, does this policy actually satisfy EPA's Section 7 consultation duties? We took a look at Section 7 of the ESA, what it requires, and I think there's a really interesting question there as to whether the ESA, whether those Section 7 duties are going to be satisfied by EPA introducing early mitigation measures. It's not, these mitigation measures are not being developed as part of a Section 7 consultation process. They are being developed in the hopes that in the future, the Section 7 process will result in fewer jeopardy findings. So, does this policy actually satisfy the Endangered Species Act? I think there's a lot of wiggle room there. I think another great question is, does this policy satisfy FIFRA's unreasonable adverse effects standard? If EPA is going to be modifying these pesticide labels, it's going to need to make this FIFRA determination, and it's going to need to do that balancing test. And I think there is, again, some really good discussion about whether or not this policy is going to correctly and appropriately satisfy that standard. I think there are questions about what happens if there's some conflicting state law. There's certainly questions about the sufficiency of the species maps that EPA is using to identify sort of where these vulnerable species are located. There's also a lot of questions about who's liable for violations of these policies. Does this make applicators more at risk for, being liable for Endangered Species Act violations? Does it increase their risk for being liable for FIFRA violations? It's hard to say right now. And I think, again, kind of tying into that, are farmers going to become more vulnerable to Endangered Species Act lawsuits? The ESA has a pretty robust citizen suit provision. So that's just something to be aware of there. And with that, I think that is the last of my slides. And we will now turn this over to discussion and questions. And I hope that you will have some good ones.
Thank you very much, Bridget. Really like that overview. We do have some questions, and I'll start with one on Section 7 consultation process.
Wonderful.
Where in the process do positive impacts of pesticides have on endangered species habitat come into play, especially when 42% of threatened or endangered species are at risk due to invasive species?
That's a really great question. I would say that most likely it's going to come into play in two areas. So first, during that informal consultation, process, when an agency is first kind of determining, will this action have an impact on listed species? If the action is, say, registering a pesticide, and perhaps the pesticide is going to be used to target some kind of invasive species, or we've seen that it reduces, say, an invasive species that is particularly harmful to a listed species, EPA will probably take that into account there. It's also probably going to be considering that when it's making that, kind of determination, if it's determined that, yes, this action may affect a listed species, if the agency is then breaking that out to kind of make that likely to adversely affect or not likely to adversely affect, that might be where the agency considers, wow, this pesticide we've seen that the impacts are really maybe more beneficial to the species, so we don't think it's likely to adversely affect. That might be where that comes into play. And then the other area where that's going to come into play is if we get to formal consultation and Fish and Wildlife Service is going through and drafting a biological opinion. They are supposed to be taking a very close look at all the expected impacts. And that is where we would see, a really thorough look, or where we would expect to see a very thorough look at all the potential outcomes. And that is something that could contribute to a finding of no jeopardy, just depending on the situation. But that's where I would expect those impacts to really be examined, is during informal consultation. And then if the consultation process proceeds to formal consultation, in that biological opinion, that is absolutely something that Fish and Wildlife Service, we would expect them to really be critically examining and really looking into.
Related question, but looking at FIFRA, since ESA looks at risk primarily, considers benefits tangentially, then doesn't the benefit consideration under FIFRA play a role, or is it moot?
That is a really good question. And I think that kind of gets to the heart of where these two statutes intersect and what has been so challenging for EPA in trying to satisfy both of these statutes. Because the ESA is so, that may affect standard is so low, you really, any impact, positive, negative, whatever it is going to trigger that standard. And if you are then evaluating under the ESA, you really are supposed to be looking under the ESA's standards, under their regulations, under that, and not, take into account whatever else is going on. So I think that's a really important question, because both of these statutes do have these environmental standards that need to be met. And yet, if you are EPA, or if you are the services, you're sort of doing this ESA evaluation portion, you really are supposed to be limited to looking at the ESA and making those decisions under there. And I think that is where then that question becomes very relevant. What role should the FIFRA standard and the weighing of the costs and benefits play? Under the black letter of the law, if you're Fish and Wildlife Service and you're drafting your biological opinion, you are really only supposed to be operating pursuant to the Endangered Species Act. But I think the challenge for EPA has been, it needs to be complying with both. And I don't have a perfect answer for how the agency should be doing that, or what the correct legal answer is fully. I think that's something that judges are also still grappling with as they sort of deal with these lawsuits and try to kind of come up with the right approach there. But I think that's a really good question. I don't have a perfect answer for you. But I think it really does get to the heart of EPA's challenge, is how is it supposed to square both of these standards at the same time?
Getting to roles that you just mentioned and the uncertainties there, how under our existing authorities can EPA make considerations or decisions under ESA when the services are the administrating agency for that act?
That is a great question. So
we like
the service, yeah. No, I'm trying to think of the best way to frame it. When the services do administer the ESA, they have certain responsibilities under that act, and they are tasked with carrying it out, with enforcing it, with all that fun stuff. However, the ESA is sort of a unique statute because it gives all federal, I actually don't want to say unique, because there is another statute I can think of that does this, but one of the quirks of the ESA is that it also charges every federal agency with this responsibility to consult. They're not necessarily administering the act, right? But they do have this duty under the act to go through this consultation process whenever they carry out an action. This is something that's been part of the act since the beginning. Now, I think the trickier part is does EPA have the authority to create these Endangered Species Act, these sort of early mitigations, and introduce them and sort of say, we're introducing this under the authority of the Endangered Species Act? I think that is, at this moment, an unanswered question. I know that USDA left a comment on, I believe it was the draft herbicide strategy, where they raised that very concern, where they said, we really don't know whether EPA has the authority under the Endangered Species Act to be taking these steps, to be introducing these early mitigations. And I think that is a very big open question that right now we do not have an answer to. And it would not surprise me if, especially if this policy kind of gets carried out sort of as EPA is envisioning, it would not surprise me if we saw some litigation over that in the future. I don't know when, I don't know who would be filing it, but it would not surprise me if that was something that we see come up later, because I think that is the crucial question here. Does EPA have the authority under the Endangered Species Act to be making these early mitigations? And I don't have the answer.
Well, that's a good food for thought. Likewise, when you're talking about early mitigation, from a legal perspective, what are the implications of adding restrictions before a FIFRA or ESA process is undertaken, essentially, and there's no determined fact of the need for a restriction?
Yeah, I think that's another, again, great question that gets to the heart of how feasible this policy is going to be. If EPA does go ahead and incorporate any of these mitigations into a pesticide label, we sort of have this idea under FIFRA, and I'm sure most of you have heard this saying before, that the label is the law. So if something is included on a FIFRA label and has been, registered and determined by EPA, then it's a part of the label and it's a part of the law. So even if we see a mitigation measure introduced that was not developed pursuant to Section 7 consultation, if EPA has sort of dotted all of its I's and crossed all of its T's and added this mitigation measure to a label appropriately, then it certainly is going to sort of be there under FIFRA at least. So under that idea that once it's sort of on a pesticide label, then it's going to be part of the label and it needs to be followed. Where that sort of fits in with ESA's Section 7 consultation process, I think is really what's the big question in the room. We got a little glimpse of this earlier in very early 2022, when sort of out of kind of the early stages of the vulnerable species pilot program, one of the species that was one of that initial set of 27 was I think it's a threatened species, but it's the American burying beetle. And when EPA sort of released its labels for Enlist 1 and Enlist Duo for that year's growing season, there were restrictions that had been incorporated through those bulletins that we talked about, that EPA had sort of developed, I think it with the registrant, and had gone through and added them to the label in the appropriate FIFRA process. And these were mitigation measures designed to reduce impacts from Enlist 1 and Enlist Duo to the American burying beetle. And some of those were avoidance mitigations. So some counties got completely off-listed for those two pesticides. And in my state, in Arkansas, we had several counties that were off-listed, and were actually able to kind of work with EPA and work with the registrant to end up getting on-listed again, because while the American burying beetle has habitat in those counties, the American burying beetle was not actually present in those counties. So they were able to get on-listed. And I bring this up because I think this is a good example of sort of the agency didn't go through its Section 7 consultation process. They actually just completed their Section 7 consultation process for Enlist 1 and Enlist Duo earlier this year, last month. I think they came out with that, or possibly earlier this month. But they had these mitigation measures included, and they were correctly included under FIFRA. But because that Section 7 consultation process had not been fully completed, and because you had folks in these counties that were able to show that the American burying beetle wasn't actually present, they were able to remove those restrictions. So I think we're going to see some weird stuff kind of going on where you do have EPA adding these mitigation measures appropriately under FIFRA, but because they haven't fully completed ESA Section 7 consultation, there's going to be some sticky stuff going on. Which again is to say, I think this is a really critical question when we're looking at this policy, and I don't think we have a perfect answer right now. And I feel like I keep saying that, I'm so sorry. But I think this is one of those situations where we have these two statutes at play. We understand how they work, but we're not really sure if they work in the way that EPA is proposing. So there's going to be a lot of waiting to see.
Okay. We'll move on to a little bit more specifics now with respect to some of the current events and the specific cases. Can you address the tentative agreement from CBD and others on the mega cases that are pushing these timelines that we have?
Yes. So this was a settlement agreement that came out earlier this year in June. It's been, it's a formal settlement agreement between EPA and Center for Biological Diversity and the other parties to these lawsuits, which had been going on for, goodness, I think over a decade, included over 1,000 pesticide labels, all really with that same argument that EPA had not fully carried out Section 7 consultation. And I've seen some confusion over this settlement where I've seen some folks think that this settlement is sort of what created this new policy approach. And I do want to clarify that it's not this settlement that's created this new policy approach. EPA has been developing this policy since I first became aware of it in 2021. So they've been working on this for a couple of years. What this settlement does do is commit EPA to certain timelines. So those timelines include completion of a final herbicide strategy. So that draft herbicide strategy that we looked at earlier, under this settlement, EPA has agreed to complete it by sometime next year. They've also committed to a timeline to produce a draft insecticide strategy, again, issuing it sometime next year. And they've committed to carrying on and sort of developing the vulnerable species pesticide program. So, and because these are now part of a court settlement, this does give the other parties to this court settlement some room. If EPA does not complete these timelines, this does give these parties some room to kind of push back or even go to court again to get EPA to fully comply with the settlement there. So it'll be interesting to see how that gets worked out. But I think the important takeaway from that settlement agreement, it commits EPA to certain timelines for some aspects of this policy. It doesn't necessarily commit EPA to certain timelines for when the policy will be actually implemented, just timelines for sort of completing some of these documents. So some good news there, maybe, if you're a little unsure about this policy in general, but it also does mean that EPA is showing a commitment to continuing to at least develop the policy.
All right, and there's a related question here about pesticide applicators and their exposure. How will pesticide applicators be able to protect themselves from citizen lawsuits under this nebulous framework? California's Clean Water Act implementation opened a Pandora's box of litigation for industry, agriculture, and municipalities where defendants could not win. How do we prepare our applicators for this?
I think that's a really good question. And I think this concern over liability is something I have seen raised from a lot of different sectors and avenues. And I think is certainly something that's going to be talked about a lot as this policy gets further developed and eventually implemented. So the Endangered Species Act, like I said before, has a very robust citizen suit provision. It allows any citizen group to sue any party who they believe is violating the Endangered Species Act and sort of get them to stop. I think unquestionably, this policy does open up the door for increased risk to applicators. I don't necessarily think that there's going to be a deluge of these, at least not initially, in part because it's going to be, I think, tricky to prove. And that's where a lot of these lawsuits usually get mired in the muck is, it might be really difficult to prove that someone has violated a pesticide label or has specifically, violated the Endangered Species Act. However, any litigation is going to be time consuming, resource consuming. It can really be a drain. I think that something applicators should keep an eye out for. EPA has announced that they will be focusing on doing more outreach and education. There has been a huge call for training sessions for applicators. So I would say one of the best things that applicators can do is to make sure they attend these trainings. And anyone who is concerned, I think, specifically about this question of liability should be keeping an eye out for any of EPA's listening sessions, anything where they make it available for the public to kind of come in and raise this concern. Because I think that's something that they should be including in their applicator trainings, is how are you going to be kind of protecting yourself from liability there. So I would say, one, to prepare yourself, keep an eye out for any trainings that you're going to be able to go to, and then make sure you're asking EPA these questions. And if you're attending an EPA listening session about this, a roundtable, if you are maybe even sending in a comment on one of these draft plans, raise that as a concern, because that is something I think the agency should be aware of.
Very helpful. We have a few more questions here, and they're more related to specifics to do with the mitigations themselves.
Mhm.
And first one here, for the herbicide strategy, do you have a sense of which mitigations will appear on labels versus those on BLT? Will the point system be on labels or BLT?
That is a good question. I don't know yet. EPA has not really indicated what they're going to be including on the general labels versus what's going on the BLT, beyond really just saying those those mitigation measures that we think apply generally across a pesticide's entire use area will be on the general label, and that those that are more geographically specific will be on BLT. So I'm assuming that means that if a point system is required across the entire pesticide use area, then that would get incorporated into the general label as opposed to being on a BLT. But it's also, until we sort of see how EPA does it, or until they provide us with some more specific information, we just don't know.
Another one is related to plant protection.
Mhm.
Plant incorporated protectants. Are there any expected effects on these products with respect to what's happening here?
Not that I have seen yet. EPA seems to be focusing on conventional pesticides and really those herbicides, insecticides, and rodenticides. But that's not to say we couldn't see changes in the future, especially since we're still in what I would call the early days of this.
Okay. And then a question related to buffers with a couple of dynamics here. It's a threefold question as presented. Implementation of buffers could have an economic impact on crop production in areas where it is required. Versions of the plan discuss buffers neighboring public lands. Is that only federal public lands or state and county public lands also? Was the economic impact to farm production due to buffers analyzed? And finally, how was existing drift-related restrictions how were existing drift-related restrictions not already considered accurate and adequate?
Those are some great questions. I'm going to do my best with these. Some of these are, very specific, and I think probably only EPA is going to be able to answer accurately what they did and did not consider. However, I can say when you go and you look at the draft herbicide strategy, which I have and read all the way through, if you need some very convoluted reading to put you to sleep, recommend. But if you're looking for a fun beach read, that's not it. They spend a lot of time looking at species impacts and distance from application and drift, but they're not in that herbicide strategy including economic impacts, at least not that I saw. It is possible that that is something they have been considering, but I can tell you that these work plans, that the two initial work plans that they released one in April 2022, one in November 2022, and then both the draft herbicide strategy and the draft vulnerable species pilot project. I did not see really much consideration of economic impacts to farms there, really at all. And as to sort of how were they considering existing, buffers and existing spray drift requirements, I think because EPA is sort of saying we're adding all these spray drift requirements on top of everything else. I'm not sure the degree to which the agency is sort of walking through each label and really evaluating all of the restrictions on each one. They really do seem to be considering, however, the agency seems to believe that these spray drift requirements are necessary across the board. So to me, that says that they at least believe that whatever is in place currently is not enough. But again, it's not necessarily clear to me at this point the degree to which EPA is specifically walking through every single label. And I'll be kind of sneaky and tap the other panelists to say if anyone has heard anything different or has any further insight and would like to share it, feel free. But that's sort of my understanding at this time.
Your question was kind, and I was just going to move to Stanley and Tony, if Tony is at a place where he can speak, and ask them since we're getting down here to labeling issues and product use issues, what their thoughts might be. Stanley, you have anything you want to add there?
The only thing I would add in both comments to vulnerable species and herbicide strategy, we actually did provide a significant amount of economic data on the impact from buffers, whether it's, I think we did 110 downwind, 240 downwind, as well as 310 plus 57. So what they do with that information, we'll have to wait and see, but they have been provided that information, and it should at least be on their radar.
Tony, are you available to talk? If so, have any comment?
I don't think any further comment from what Stanley just said, Burnley.
And that makes perfect sense to me, that the agency very likely, yes, has that information, has been provided with it. What they choose to do with it is a whole other kettle of fish.
That's right. I'm not seeing any additional questions, I don't think, from our audience. I do have one request I'll pass on as I pass this, Bridget, on to Chris. Do you have any final comments, Bridget, before we pass it on?
Thank you once again to the entire cast team for having me. I enjoy getting to talk about this and getting to share this information. And I would say for anyone who maybe has a question later on, please feel free to reach out to either myself or the center director, Harrison Pittman. We are happy to answer any questions that we can. And if we can't answer a question, we can usually put you in touch with someone who is able to. And then that QR code you see on the screen, it takes you to sign up for the National Ag Law Center's bi-weekly newsletter, where we try to keep you abreast of interesting legal developments in the ag arena, including developments like this. So if that's something that interests you, feel free to check out our website or scan the QR code. But I think that is it from me. So just once again, thank you so much. I've really enjoyed getting to come speak today.
Thank you, Bridget. Chris, I'll pass this back to you. We do have one question since, Bridget, you brought up an interesting subject here for one of our audience, and that is the California Clean Water Act. Wonders if you might consider doing a presentation webinar on that someday in the future.
You know what? I am actually from California, born and raised, and I love nothing more than getting into California's weird legal system. It really is like its own country out there, isn't it? Duly noted, and I will keep that in mind for future presentations. Absolutely.
Thank you. Chris?
Awesome. Thank you, Bernalyn. Thank you, Bridget. Very great presentation. We appreciate the time today. Thank you also, Tony and Stanley, for coming back for today's discussion. So just a few closing comments, folks. I want to thank everybody for your participation. Those that asked questions, sounds like they were great questions. Thank you for doing that. And certainly come back for our remaining webinars on FIFRA ESA. You can see we have some in January, February, and then one in March as well. We have 4 more total leading up to a full paper rollout in April, mid-April at Crop Life's RISE conference in Arlington, Virginia. We hope you can join us for that. So more to come on that specific event. But you can see we got some great topics coming up. And if you want a well-rounded education on this very thing of FIFRA ESA, please do indeed come back. As always, I'd like to post our contact information. Feel free to reach out to CAST at any time. We'd be happy to hear from you, happy to improve on what we're doing, happy to engage with you in a variety of other ways. So with that, I want to thank everybody for joining today. I wish you all a wonderful week and a happy holiday season. Take care, everyone. Bye-bye.